back to the show. This is The Law Show on CL 650.
It's my life, it's now or never. I ain't gonna live forever.
Is this the first time that Bon Jovi has been played on CL? I think it is.
I think so.
All right. It is The Law Show, and we're talking about family law, the breakup of relationships. We've touched on abusive relationships and different kinds of protection orders. And I want to talk about how you ultimately get to the end of a divorce with something like this. I see something here. What's a conduct order?
Well, conduct order is not quite a protection order. So there's, you may say that the parties will can only contact during certain times.
Communicate by email only.
Yeah, it's a lot broader, but it doesn't raise. You don't have to register it in the protection order registry because when there's a protection order, the order form is different than a normal order. You have to send it off to a registry. It gets into a database so that the appropriate authorities have it there. A conduct order is just saying, yeah, as Sarah said, you're going to contact by email. It's you can only contact each other for the purpose of discussing the children, those kind of things.
Mm-hmm. All right. Well, that solves that. Now, when you have an abusive situation, maybe you've got a protection order, and you've got somebody in the relationship who is physically abusive, mentally abusive, what have you. How do you get to the end of the divorce? How do you? It must be quite something to stick handle.
It's a different situation than your normal case where you come in. Every case that we deal with has one party who is the dominant party in the relationship, either be economically, physically, and I don't necessarily mean even violence-wise. It's just dominant personalities, etc. But when you add the violence in, there's the extra level that you have to deal with because you have to make sure that your client is not, if you act for the abused or the one that was allegedly abused, you have to make sure that she or he are settling only because it's actually in their best interest. They're not settling it just because they're afraid of the spouse. Mm-hmm. Because I know a lot of people, they've settled in the past or wanted to settle, and they've said to me, I just want it over with. I want rid of the person. I don't want to put up with this bullying. I don't want to put up with this. And they may be selling themselves short because they're only settling if there was abusive, they're settling just to get rid of the person.
Well, that's bullying as well.
Exactly.
Yeah, because if you're giving up a whole bunch in your settlement,
exactly,
then it's the final bullying.
You've been abused a second time.
Yeah.
Now, I will admit there are some people who they were abused and they know they're taking less, but they're making a free decision because they've been away from the abuse for a while. So I'm not putting up with him doing this to me anymore. I had a case a number of years ago, and it was before we were a lot more, in tune with abusive relationships. So it was 10, 12 years ago. And this client took far less in spousal than in court she would have received. Because at the time, she probably would have gotten, at the minimum, 7, 8 years. And she said, I'll take it for 3, and it was a lot less money than I think she could have gotten. And I explained to her, you're entitled to more. Why are you doing this? She goes, because he was economically, abusive is what we'd consider it now in 2016, controlling me money-wise. She goes, and I'm not going to put myself in that position where I have to go and grovel on my knees to him for a check every month. Mm-hmm. Even though it would have been empowering to get the money and use it herself, she was not putting herself in the position to do that. So even though she'd been abusive and she was settling with a bully, she was doing it because she felt empowered that she didn't need to put up with his stuff anymore.
Mm-hmm. So she took like a one-time settlement.
Exactly.
Just to make sure she never had to.
I don't have to deal with his.
Because then he would have control again.
Exactly. Yeah. So in effect, she was breaking through the abusive by not putting up with it anymore. Mm-hmm. But, it's difficult because we all have clients who take far less than they should. Like I had one person one time come in and she was taking nothing. And I couldn't understand he was so abusive. She wanted rid of him for so much. And so our job, Sarah and my job as a lawyer, is to make sure that they're settling of their own free will and not because they're afraid of the other person. Like, don't settle it because if I don't take this, he's going to get mad at me.
Right. Okay, so when you're actually going through the negotiation process and you have to kind of ultimately get to the point where you're going to have a divorce, how do you negotiate with somebody like that? And is it mediation? How do you do it?
Well, and that is going to depend on, like you said, sort of, what sort of factors are present, and if there is, what David is alluding to is sort of a power imbalance. So we have to screen for that to see, is there sort of a power imbalance, and is it possible to negotiate fairly? With respect specifically to mediation is sort of a bit of a different animal, because you have to have two people that are willing to compromise, essentially. So they're making their own decision. As mediators, we just sort of help them along the way. And if there's a power imbalance, there's a question as to whether are you able to actually mediate if there's that power imbalance. So we do actually screen for that. We're trained to screen for violence, and we'll screen for that when we're doing our pre-mediation meeting with each party. And we'll sometimes set it up if we think it's okay to proceed in the actual mediation. We will set up safety words or code or something along those lines for if the party, the potentially abused party, is feeling threatened or uncomfortable. And it may be something as simple as a cough or a gesture, and then we'll take a break and take them outside.
And does mediation always have to be face-to-face?
Typically, but it typically doesn't have to be. But what we can do, and I've even done this in 4A meetings, is shuttle mediation. So you'll have a main room and then two separate rooms.
It's kind of like union negotiations.
Yeah, that's exactly it. So you'll shuttle from room to room. So you can still have your whiteboard with your brainstorming and things like that, trying to come to some common ground. But that face-to-face isn't there. So you're able to sort of remove that power imbalance potentially.
You must have clients who say, I never want to see that person again.
Oh, yeah.
And
I think that's all of our files.
Yeah, exactly. Yeah.
But just physically don't want to be in the same room with them.
Oh,
So
absolutely.
I have a lot of them that I suggest a meeting and they're fine with it. Then I get an email later that says, I don't know if I really want to be in the same room with them. For whatever reason, it may not even have been that they were abusive. It's just how they broke up, whether the person left them for someone else, wherever. They just don't want to be there with them. And as I tell my clients, I don't want you to do anything that's going to make you uncomfortable. If you want, I'll go down and meet with the other lawyer, and I'll sit down myself and see what we can come up with, subject to getting your instructions afterwards. There's a lot of ways we can work around it to make all our clients comfortable and make sure that the settlement is a fair and reasonable one.
Absolutely. And you can come with some creative solutions. I was in an examination for discovery where my client did not want to have the other party look at her because there had been a very big power imbalance and sort of an abusive relationship. So we angled a television and the coffee service and our chairs in a way that they didn't have to look at each other, and we moved things around as the day progressed, and she was okay with that. She's like, as long as I don't have to look him in the face, that's going to make me feel better.
Because a lot of them also, when if there was a power imbalance or abuse, they still get intimidated just by the person sitting there across from them, and they may see them through the corner of their eye, and it affects their testimony when they're giving their examination or in the courthouse witness box or whatever.
So, changing subjects a little bit, when people are divorcing, which situations make it the most acrimonious? Is it someone left for someone else? Is that typically it?
Yeah, that's usually a nice factor. Although, interesting in that, men seem to take that far harder and get more upset than women do. That's not to say that women don't get hurt and don't get upset when they were left for someone else, but men seem to take it far more personally.
Because we got big egos.
Exactly.
That's why.
Exactly. And as I tell some of my, my female clients, when the guy's acting really weird, if they're off with someone else, I say, well, it's a guy thing. So, and that's one thing where it's good when your client is of one gender and you're the other, because I can understand where he's coming from. And so if Sarah's acting for a guy, she'll understand what the wife is going through, and we can, you go that stuff. But that's the one thing for sure. If it was an abusive situation, is acrimony when the person is realized and has become empowered that they're not putting up with it anymore. It can cause a lot of acrimony. But usually when you're left for someone, that's usually
when they're the most vindictive, right?
Yeah.
And especially when you weren't expecting it. Like a lot of people, they know that they're going to get divorced they may not say it verbally, but in their head they know for some time before.
This marriage has been cooked for a while, right?
Exactly.
Yeah.
When it just comes out of nowhere, someone that I know closely had no idea that the husband didn't want to be with her anymore. And just out of the blue one day says, I don't really want to be married anymore. And it was like completely floored. You weren't expecting it because, thought everything was fine. So it's when one doesn't expect it, it can be tough.
I'd agree with that. Yeah, that my most difficult file from an emotional standpoint was the wife was completely blindsided, had no idea. She thought they were just working things out. He had a completely separate life. So I found that was the most emotional.
How many divorces come in and it's easy from beginning to end? Out of 100?
Maybe 10 to 15. For me, maybe 10 to 15%. It depends. I guess maybe I have a different definition of easy than Sarah has.
Well, maybe what I'm getting at is that they've kind of just said, look, we're not going to fight over everything. Yep. We'll split everything 50-50. We'll come to a sensible agreement with the children. Let's just get this thing done.
About 10%.
Yeah.
And that's typically people that come in for separation agreements. They already know that's what they want to do. So, yeah, that'd be a bit
and then over time, there may be one or two issues that are tough on the next 40%. It's really only maybe 10% of the files where everything is fought over. There's that, was it that rule that 20% of your clients take 80% of your time? Mm-hmm. And that's basically the same with us. We have if Sarah and I may have 80 files each, there may be 5 or 6 of them that take up like 3/4 of our days.
Yeah. And I guess you must have a lot of people who have already kind of decided what they're going to do. Is that what you mean by separation agreement? Like they've already kind of hammered it out. You've just got to formalize it for them.
Yeah.
Yeah, and maybe negotiate a few things, maybe get full disclosure or, hammer
Make sure
out
everything's okay.
Yeah, give them some more ideas on, well, you might want to actually address this type of parenting time long term, or what about this schedule? This might work a bit better. Maybe you want travel authorizations and things like that. So we just help with our experience. We're able to say, well, have you thought about
the pertinent
this?
questions, yeah.
Exactly.
All right, my last pertinent question. What's your number one piece of advice to somebody who's listening to this radio show who has not yet started divorce proceedings, but maybe is thinking about it?
Well, certainly I think that what they should do is call us up and have a consult to see where they're at, because a lot of times what people think their rights aren't their rights, or they think they're not entitled to as much as they're entitled to.
All right, there you go. I love the free legal advice. If we build this out, both of your hourly rate. Wow, people got a real deal.
Exactly.
Listening to CIL 650. Thank you very much. I love the law show. I learned so much. I'm going to start teaching a class. No, I'm just kidding. Family law, it's a lot of fun to talk, because if you're not going through it, it's easy.
It's a tough time.
If you're going through it, it's not so easy. David Halkett, partner at Macquarie Hunter, thank you for your time. And Sarah Morse, appreciate it. It's always great seeing both of you.
Thanks a lot.
Thanks for having us.
That's it this week for the Law Show. I'm Zach Spencer. Speak to you next time.